Hello friends, good afternoon and welcome to Edusat live lectures. Friends, as you know that it is our continuous effort to bring knowledge-enriched lectures for your benefit. And today also we have brought yet another lecture in the similar pursuit. Today we are going to discuss about judiciary in India with a special focus on Supreme Court in India. In this lecture we will try to understand its function, its formation and various debates regarding judiciary, for example, judicial review and judicial activism. To discuss this topic, we have with us our subject expert, Dr. Satish Kumar Jha. Dr. Jha is Associate Professor in Department of Political Science and Aryabhatta College, University of Delhi. Dr. Jha has over 25 years of teaching experience and his area of expertise lies in political theory and in Indian political thought. Without further ado, I would like to welcome Sir to our studios and request him to start the lecture. Welcome, Sir.
Thank you, Amrit. And good afternoon. Today's lecture we are going to devote on judiciary in India, particularly with reference to the Supreme Court, the highest court of the land. In fact, in course of our discussion in next 1 hour, we will focus on 3-4 important issues related to judiciary in India. First of all, out of the 3 branches, the legislature, executive and judiciary, judiciary of late is becoming perhaps a very salient and significant arm of the polity. Though one thing we should bear in mind that this is the only institution or only arm of the state which is apolitical to great extent. Number 2, in fact, India does not have a kind of separation of power doctrine the way in fact it is available in United States of America and other countries, but still it is quite latent in the entire philosophy and spirit of the constitution that the 3 branches of government, legislature, executive and judiciary, they have been earmarked their area of operation and area of of jurisdiction. Therefore, even if we do not have a strict separation of power doctrine in the constitution like United States of America, but nonetheless the 3 branches are supposed to work in their respective domain. But of late number of issues have come up where Indian judiciary, particularly the Supreme Court, has shown inclination to to act in certain areas which perhaps in the opinion of scholars do not lie within the exclusive domain of the Supreme Court, and therefore a number of issues have come up, including the charge that judiciary in India has become activist. At times it is referred as judicial activism, sometimes it is called judiciary's overreach, and so on and so forth. So we will also look at those issues. The second thing is that judicial review of course is important component of Indian Supreme Court, Indian judiciary and the Indian constitution. But nonetheless the concept of judicial review in India is different from the way it is understood and the way it works in United States of America, the classical land of one can say judicial review, though even in United States of America it was not integral part of the original constitution. Rather it was basically arrogated, the judiciary arrogated to itself, the Supreme Court arrogated to itself this power through that famous judgment called Marwari versus Madison case with the ingenuity of Justice Marshall. But in India this has been made part of the Indian constitution itself, and of course with some major differences. For example, whereas United States of America uses the term due process of law, Indian constitution and constitution makers decided to go for a different term that is the procedure established by law. In fact, there is a great amount of difference in terms of the usage of 2 things and with significant implications. Due process gives unfettered power to judiciary to interpret laws and actions of executive and legislature based on natural law, natural rights and natural justice, and therefore the Indian founding fathers believed that such doctrine often leads to large amount of litigation, and therefore, in order to reduce the possibility of litigation, future litigation, they tried to be more specific and use the term called procedure established by law, particularly in Article 21. So, therefore, we have to keep the differences between the Indian and the American American counterpart, so far as the concept of judicial review is concerned. But of late, perhaps the founding fathers should not have imagined, because the way the Indian judiciary has moved far away from that doctrine, and in course of that evolution, in course of that judicial ingenuity, in course of judicial innovations, in fact, Indian Supreme Court has to some extent even gone beyond what United States of America is known all about. For example, about American Constitution, it is normally argued that in America the Constitution is what judges say, as Chief Justice Hughes once said. But in India, that was not the case. There was neither the supremacy of parliament nor the supremacy of judiciary, but rather, in the opinion of many legal experts, it was the supremacy of the Constitution, the textual supremacy, the supreme, the Constitution as a document was supreme, and all branches of government had to work within the broad purview of the constitutional laws and constitutional discourse. But of late, what is being argued, that the Indian judiciary has basically overstepped its jurisdiction, or basically has gone beyond its its powers and functions which were prescribed or given in the Constitution. And in course of that, what it has done, that it has basically overshadowed the two other branches, executive and the legislature. So, that is a matter of controversy and debate, including the process of the appointment of the judges, because India is perhaps the only instance in the world where judiciary, particularly the Supreme Court judges and High Court judges, are appointed by the judges themselves. So, they are accountable to themselves, not accountable to any other institution. So, I mean, gradually this mitigation of executive role in the entire process of appointment of judiciary, also one issue which is at times highlighted and raised, so far as the growing power of, or the growing role of judiciary in Indian polity is concerned. So, we will look at all these issues in course of our discussion: the appointment controversy, the working debate, the debate on the working of the judiciary, the Supreme Court, and particularly issues related to judicial review and judicial activism. But before we move on to those issues, we should first of all remember that India has established a hierarchical system of judiciary in India. In this hierarchy, the Supreme Court stands at the top, whereas the Gram Kacharis at the bottom, at the Gram Panchayat level, at the grassroots level. In between, you have the High Court at the state level and the subordinate judiciary at the district level. So, therefore, this is a hierarchical judicial system in India, one unified hierarchical. Unlike many other federal polities, we do not have a kind of dual judicial system, rather one hierarchical judicial system. Now, one thing also is important to remember, that out of this hierarchical arrangement, the Supreme Court and High Courts in India, they deal with all types of cases, civil, criminal and revenue. Whereas, when you go lower in this ladder, then we find that the district courts, at district level, the judiciary is divided into two parts, the civil and the criminal. The district courts are essentially essentially meant to deal with the civil cases, whereas the session courts deal with the criminal cases. So, this is overall a structural arrangement of the Indian judiciary in a hierarchical unified fashion. So far as the position of judiciary in Indian polity is concerned, we should remember that there are two sources of power in India, particularly Indian constitution. One is the popular sovereignty, another is the legal transfer of power, basically done by the British colonial powers. So, therefore, what happened that the power, the entire concept of power or entire structure of power is derived from two sources. Some of the legal provisions in the constitution which basically come from 1935 Act, and therefore, the legal transfer of power which was done by the British Parliament is also one source of power, but another is the popular sovereignty, the sovereignty of the people, and that is why the preamble opens with this sentence that we the people of India. So, therefore, these two sources of power are there, but at the same time because India is a democracy, there are also two sources of mandate, two sources of authority. Within this popular sovereignty, one can say that there are two sources, and one source is this electoral mandate, which is basically updated and which is updated after every 5 years. That is how the people elect their representatives. They go to the parliament and then they govern through executive and by making laws, by amending constitution and so on and so forth. And then there is a constitutional mandate apart from this electoral mandate which comes from time to time through process of election. There is a constitutional mandate, and that mandate is available in that document that is called Constitution of India. But what happens at times when there is a conflict between these two mandates, the electoral mandate as basically articulated by people through periodic elections, and the constitutional mandate which is available in the text of the constitution, what we find that often this conflict surfaces that which should get primacy, because this electoral mandate as reflected in the composition of parliament, as it reflected in the parliamentary process, and parliament at times and from time to time rather tries to implement the constitution, enforce many provisions of the constitution, and at times also tries to amend the constitution. That comes into conflict with this constitutional mandate, that is basically the constitution and its custodian, that is the Supreme Court of India. Though it is a different matter that in democracy parliament is as much custodian of constitution as a judiciary, but nonetheless this fight is often unresolved in modern democracies, that where the ultimate sovereignty lies, whether the representative of the people or the interpreter of the law and constitution, that is a judiciary. In India also you find that this conflict surfacing off and on, particularly between this electoral mandate and the constitutional mandate, and at times we have seen that the parliament, by using this electoral mandate, has basically amended the constitution, has basically tried to enforce many provisions of the constitution, including the directive principles of state policy, which it has sought to privilege our fundamental rights on number of occasions. And the Supreme Court, particularly in the later period, particularly in last 2-3 decades, have struck down many such amendments and have also given ample indications that it would not brook any interference or any tampering of the constitutional document or any provision of the constitution, which in the opinion of the Supreme Court is basically basic to the entire philosophy or the foundation of Indian polity. And therefore, in fact, in the famous Keshwanand case, in fact it devised a new doctrine, that is the basic structure doctrine, and we will basically discuss this issue when we will come to this question of judicial review in India. So therefore, this question of mandate, the two mandates, the electoral mandate and the constitutional mandate, and the conflict between the two, and that conflict often resulting into controversies and debates, and that remains unresolved and goes on even today. For example, recently we have seen that when that Act of Parliament was passed for appointment of judges through a commission, a judicial appointment commission, and it was struck down by the Supreme Court, saying that it is violative of the basic structure of the constitution. So therefore, even in matter of appointment, the attempt of the legislature and executive to have some say, particularly the attempt of the executive to have a say in this appointing process of the judges is not being allowed by the Supreme Court of India in name of basic structure of the constitution. So therefore, that this question remains unresolved. that who is the final arbiter of the constitution, whether it is the judiciary or the parliament. And if we go back to the Constituent Assembly deliberations, we find that even then the members were not quite clear on this issue. A person like Ambedkar, who was the chairman of the drafting committee, who basically brought lot of clarity on number of ticklish issues in the Constituent Assembly debate. On this issue, that which should be given primacy, the parliament or the judiciary. Even he was a little bit not confused, but he was not in a position to give a clear cut verdict on this, and therefore, in fact, if I remember correctly, he used the word that it was a situation of Sheila and Charybdis, that which way one should go in a democracy. If you trust the will of the people, then parliament should be given the primacy. But then at times, because of this majoritarian tendency in democracy, some of the philosophical foundations of the democracy and polity could be in danger. On the other hand, if the experts and their wisdom is trusted, that is judiciary, then basically one is basically diluting the spirit of democracy. So, it was a confusing situation for him as well, and that is amply borne out by the debate and deliberations of the Constituent Assembly. So far as Nehru, the India's first Prime Minister, is concerned, if you look at his interventions in the Constituent Assembly debate, in fact, he always believed that it is a parliament which should be considered the final arbiter of democracy, constitution and Indian polity. Therefore, he believed that the parliament should be given the final authority and say so far as the constitution is concerned, and therefore, parliament would be the custodian of the constitution and rights. But one thing is also important here to remember, that because of certain certain features of the constitution, for example, the provision of federalism and fundamental rights, along with the fact that India has a written constitution, the judicial review, particularly the role of Supreme Court, automatically became quite significant. And therefore, as it is often to be remembered, that India is neither a classical case of federalism nor the classical case of parliamentary democracy, parliamentary supremacy. Like many other Commonwealth countries, India basically combines the features of the two, and this combination has tremendous implication so far as the role of the judiciary is concerned, because the moment India is going for a federal polity, center-state relations, particularly the 7th schedule, where the powers of the center and states has been divided, the role of the Supreme Court definitely becomes quite significant. So, and therefore, one has to see that how this provision, how this entire federal discourse in India has given a privileged position to the judiciary, particularly the Supreme Court of India, because this is also one of its original jurisdiction. We will basically look at some of the powers and jurisdiction of the Supreme Court, and one of the important jurisdiction is the original jurisdiction, and center-state relations and the federal fight comes under the original jurisdiction of the Supreme Court. Similarly, fundamental rights and the written constitution, like United States of America. So, these things are also important, because the Supreme Court of India and also high courts under article 226, whereas Supreme Court under article 32 are basically empowered to issue number of writs for the protection of fundamental rights, and this is one of the original jurisdiction along with the federal dimension of the polity, where the Supreme Court can issue writs under article 32 for the enforcement and the protection of fundamental rights. So, therefore, because of the special features, or one can say that by the very nature of Indian polity, Supreme Court has a special position in the entire scheme of things, and therefore, if in course of time Supreme Court has arrogated to itself some of the powers which earlier were perhaps not visualized, in fact, there is nothing surprising in it. Now, coming to the next issue, after this special position of the Supreme Court in Indian polity, the next important issue is the structure, and that structural discussion of the Supreme Court would basically require discussion of the process of appointment, the process of removal, qualification, the independence, how the independence of judiciary has been ensured, particularly the independence of Supreme Court and High Courts, and so on and so forth. So, therefore, this structure part is important to discuss. Now, in this section, we have to look at 2-3 important issues, and one of the most important issue is the issue of appointment, that how Supreme Court judges are appointed. As I was mentioning earlier, that India is the only democracy in the world where judges are appointed by judges only, and there is no executive participation or control on this appointment or appointing process. In fact, it would not be proper to say no participation. Participation is there, but ultimately after this innovation, new innovation in India, after second judge's judgment, that is 1994. In fact, what is known as advocates on record versus Union of India. In fact, this collegium system of appointment which has emerged in India, and recently when this attempt was made by the parliament to pass this bill or to pass this act through which a commission, judicial appointment commission would come into existence and will basically solicit the opinion of the Supreme Court judges, executive, particularly the law minister, so on and so forth, and through this consultation process, consultation between executive and judiciary, the entire appointment will take place. This was not considered constitutional and legal by the Supreme Court, and recently it struck down and said that the old collegium system would continue, except the fact that a kind of memorandum of understanding would be developed, under which a proper consultation mechanism would take place between executive and judiciary. So, therefore, the Supreme Court judges and their appointment, High Court judges and their appointment have been a matter of controversy in recent years. Particularly, there have been 3 important judgments, the 3 judges judgment it is called. The first was 1982, it is called S.P. Gupta case. The second was the advocates on record case 1994, which is also known as second judge's judgment. And the third was, of course, through the presidential reference in 1998 when K.R. Narayanan was president, and he sought the opinion of the Supreme Court under advisory jurisdiction, particularly on issue of on the meaning of this consultation, that what this consultation was all about. So, therefore, because of these 3 important landmark judgments in recent years, we have seen a significant change in the entire process of appointment of judges of Supreme Court and High Court. Of course, so far as the number of judges is concerned, it is fixed from time to time by the parliament as per the constitutional mandate, but in fact this appointment earlier was being done by the President of India in consultation with for Supreme Court, the Chief Justice and any other senior judge after the Supreme Court, after the Chief Justice, and similarly in case of High Court, the High Court Chief Justice and Supreme Court Chief Justice. So, this is how the appointment took place earlier before this collegium system of appointment came into existence. Of course, this executive control on this appointment was also not without problems. There are a number of problems one often witnessed so far as the judiciary is concerned. For example, 1973, it is quite memorable in the history of Indian democracy when 3 judges were superseded to appoint Justice A. N. Roy, the Chief Justice of India. And not only that, the then law minister Kumar Mangalam justified this decision on the floor of the parliament, and also propounded a new doctrine, that was the doctrine of committed judiciary, that democracy requires a committed judiciary. That means the committed to certain principles. It was not quite clear in his speech that what was the meaning of that commitment to the values and philosophy of the constitution, or commitment to to the ideology of the government in power. So, therefore, it was a little bit confusing at that time, but nonetheless the fact of the matter was that judges were superseded and the concept of committed judiciary came, which was also criticized later, that judiciary was getting politicized, and because of this new trend, judiciary was losing its autonomy and independence, which is perhaps one of the hallmark of any democratic polity, that judiciary has to retain its independence and autonomy from the political parties, political ideologies, and the party in the government. So, therefore, there was problem, definitely there was a problem in the earlier process of appointment, where it was getting politicized and executive was basically ignoring a number of principles through which the judiciary's autonomy and independence have to be maintained. But recent years, in order to curtail that political interference in judiciary and to ensure its independence, when judiciary moved to another extreme of devising a new mechanism, that is a collegium system, and completely ignored the role of executive, particularly in parliamentary polity, in parliamentary democracy, so far as appointment of judges is concerned. So, kind of checks and balances which should exist in this entire process perhaps completely got missed out, and therefore, earlier if you had the judicial, the political interference through executive and therefore threat to judicial independence, autonomy, later on we have discovered that it is total mitigation of the role of executive in the appointment process. And it is in this context that these three important judgments which become case laws, so far as the Indian constitution is concerned, are important. The first important case is S.P. Gupta versus Union of India 1982, and this is also known as first judge's judgment, where in fact the consultation was declared not to be a concurrence, but there must be exchange of views on merit of appointment. Now, the second judge's judgment, which is very important because it was the beginning of this collegium system, and this was 1994, when Supreme Court advocates on record case, the Supreme Court reversed the earlier view and came out with this new innovative measure, that is a collegium system, where the three senior most judges of the Supreme Court and similarly the three senior most judges of the High Court would recommend the names of the probable judges, and those judges would be appointed by the President of India. It will be only routed through the law ministry, but the executive will not have a major say in this appointing process. So, judiciary became a self-appointing institution, and therefore, what we have seen through these case laws that have completely constrained the executive so far as appointment is concerned, which is one important issue in the entire section dealing with the structure of the Supreme Court. Similarly, there are other issues of removal and other things, but appointment is a very important feature of judiciary, not only in India, but all important democratic polities in the world, including in the United States of America. Thank you. Supreme Court in Indian polity, as it is believed today, that is growing in importance, and to the extent that the two other branches of the polity, the legislature and executive, have been overshadowed because of its overreach. and this offer reach is often referred as judicial activism. But this judicial activism has not come in a day. There is a process through which it has evolved in the last 3-4 decades. There are significant case laws which tell us that how this activism has emerged. There is significant plethora of cases through which one can see that how the Supreme Court in most of the cases, but in some cases even High Court have asserted their authority and arrogated to themselves some of the powers which normally should belong to executive, particularly by issuing writs in nature of mandamus and so on and so forth, because it commands obedience or commands activity, because mandamus commands activity in the sense that it can ask a particular branch of the state, a particular instrument of the state to fall in line or to comply with the orders. So, this is how we have seen that this has grown, this judicial activism has evolved. But in fact, this structure of the Supreme Court or judiciary is concerned, it is hierarchical, unified, starting with Supreme Court on the top and Gram Kachari at the bottom, and the process of appointment of judges is very significant, particularly the higher courts of the land, that is Supreme Court and High Court. It is only through appointment that judiciary retains its autonomy and independence, and this is it is this issue of appointment which has become quite controversial in recent years in India, particularly the 3 judges judgment starting with the S.P. Gupta case in 1982, but most significantly in 1994 advocates on record case, and then subsequently in 1998 the presidential reference to the Supreme Court under advisory jurisdiction, and thereby President Narayanan sought the opinion on the issue of the meaning of this consultation. And finally, when this collegium system got institutionalized, and recent years when attempt was made to basically overturn this collegium system through a different process, when recent in recent months when the parliament passed this bill, the Supreme Court, while hearing a writ petition on this, turned it down and scrapped that provision, saying that it was violative of the basic structure of the constitution, and therefore the old system of collegium would continue so far appointment of judges is concerned. So, therefore, this is one important one can say anomaly, that in India there is no executive participation, but nonetheless one thing is very clear, that earlier when there was executive participation, in fact executive was not only monopolizing it, but was also politicizing it. In order to curtail that interference, political interference, judiciary devised this mechanism, but then there are many complaints on this also. When this this hearing was going on in Supreme Court, in fact this Attorney General cited number of instances when the quality of judicial appointment has not been has been diluted, and therefore he said that the collegium system is not working well, and therefore we should think of alternative mechanism where there is a proper consultation between executive and judiciary. This is how the constitution also talks of. This is how constitution also perhaps talks about the entire process of appointment, the due consultation between the two. But now it is not consultation in that way, rather it is simply the decision by the collegium and processing by the executive, that is law ministry and the government. So, this is something about appointment, but the removal part is also important, because when we talk of the independence of judiciary, it is not simply appointment, but also how judges are removed, because if judges are at the mercy of or at the pleasure of the executive, then the judiciary or the Supreme Court cannot command that respect or cannot act with full freedom and autonomy. Therefore, the process of removal is equally important, and it is here that we have to remember this entire process of impeachment through which judges are removed, and this process of impeachment is not easy, because the kind of strength which is prescribed, the strength of the parliament for impeaching a judge is not a very simple majority, it is a special majority, and that special majority implies that total majority of the house, that is 50 plus 1% votes, plus the 2/3 members present and voting on that occasion supporting that motion, then only a judge of a Supreme Court or High Court can be impeached. Now, this impeachment through a special majority is one of the precautions which was taken for independence and autonomy of the judiciary, and therefore, we can see that how impeachment motions have been moved against judges of the Supreme Court, of course, and the High Court, but they have not been impeached. Most of the time the judges resigned, but nonetheless impeachment motion in fact started against some of the judges in recent years. So, basically appointment and removal, the two important measures through which the autonomy and independence of judiciary in India, highest courts of the land, have been secured, and therefore, we can say that the constitution took due care, constitution makers took due care to make provision for a tough, give a tough provision for removal and particularly removal of the judges. So, for qualification of the judges of the Supreme Court is concerned, it is 5 years judgeship of a High Court or 10 years experience as advocate of High Court and the Supreme Court, or a distinguished jurist in the opinion of the President of India, that is basically the executive, but now of course, it is in the opinion of the collegium consisting of judges, senior most judges. And therefore, in recent years we have seen that some judges in Supreme Court have been appointed who were not judges of High Courts or High Courts, but they were eminent jurists in the opinion of the collegium, and therefore, they were basically appointed as judges of the Supreme Court. The next important issue after this is the jurisdiction of the Supreme Court, and this jurisdiction part is important, because this jurisdiction tells you that what are the areas in which the Supreme Court can operate, what are its original jurisdiction, what are its appellate jurisdiction, what are its advisory jurisdiction, what is the writ jurisdiction, and finally, the new innovation, that is public interest litigation, as it is called epistolary jurisdiction. So, this jurisdiction part is important. So far as Supreme Court is concerned, before we move to these three important jurisdiction, original, appellate and advisory, one thing we should remember that Supreme Court is also court of records under article 129 of the Constitution. So, therefore, in fact, it is a court of records in the sense that Supreme Court judgments become case laws, and therefore, it is referred from time to time. Now, in original jurisdiction, the first important jurisdiction, that is original jurisdiction under article 131 of the Constitution, is basically it pertains to central state relations or the federal provisions of the Constitution. So, it is exclusive jurisdiction of the Supreme Court. If there is a fight between the two states, or if there is a fight between one state and the center, or some of the states and the center, in that case it is only the Supreme Court which can hear that case and can adjudicate it. So, this is the original jurisdiction. The second is article 32, that is issuance of writs. Of course, this High Court can also issue these writs under article 226, but Supreme Court is empowered to issue writs under article 32 for enforcement and protection of fundamental rights, and 5 different types of writs: habeas corpus, certiorari, mandamus, quo warranto, and so on and so forth. So, therefore, these writs prerogative writs issued by the Supreme Court and High Court also, but so far as fundamental rights are concerned, it is the original jurisdiction of Supreme Court. If anyone's fundamental rights are encroached, he or she can straight away go to Supreme Court, and Supreme Court would not deny hearing, because it is one of the original jurisdiction. The next is the appellate jurisdiction, because it is the highest court of appeal, and under this that is article 132, this appellate jurisdiction, the Supreme Court hears all cases involving the interpretation of Constitution in all matters related to civil, criminal or otherwise. For example, in fact, in civil cases and criminal cases, it is the highest court of land, and therefore highest court of appeal. In certain cases, in fact, the High Court can give certificate that this is a fit case for Supreme Court to hear, because there are the interpretation of Constitution is involved. But in other matters, Supreme Court can also hear the cases under a special leave a petition SLP and under article 136, and therefore, what happens that when the Supreme Court believes that there is a special legal interpretation involved in it, even without the certificate being granted by the High Court, the Supreme Court can hear those cases under the provision of SLP under article 136. Now, of course, in recent years we have seen that so far the original jurisdiction is concerned, we have seen that central state relation is an important component of this original jurisdiction. But from original jurisdiction, in fact, this interwater dispute was particularly kept out of the purview of this original jurisdiction. But recent years we have seen a case law where Tamil Nadu Kaveri Sangam versus Union of India 1990, we have seen that the Supreme Court has extended the original jurisdiction to include interstate water dispute as well. So, therefore, now there is a case law under which we can say that even interstate water dispute comes under this purview of the Supreme Court of India. Now, apart from this appellate jurisdiction, there is also the third important jurisdiction, and that is the advisory jurisdiction of the Supreme Court under 143, article 143 of the Constitution. And under advisory jurisdiction, of course, whether it is binding or not, there is a debate. There are two provisions. In certain cases it may be binding or may not be binding, has been matter of debate and controversy, but normally it is believed that this advisory jurisdiction is such advices are not binding on the executive, but nonetheless President can seek advice of the Supreme Court. For example, we have seen 2-3 cases, Kerala Education Bill and Berubari case, the advice was not binding. Similarly, what we saw in 1992 on Kaveri dispute, and when a matter was referred to it on Ayodhya dispute, it was the entire reference was declared superfluous, and the Supreme Court did not give the advice. So, therefore, we have seen that advisory jurisdiction of the Supreme Court is also important, and at times the executive has used this advisory jurisdiction for political purposes, and Supreme Court has denied to fall in that trap, and basically it believes that only on constitutional matters, if the executive seeks its advice, it will give a legal constitutional advice, but not on political and ideological issues. So, apart from this 3 important jurisdiction, original, appellate and advisory, we have already seen the writ jurisdiction, that how Supreme Court issues writs, and those writs are mostly issued under article 32 for enforcement of fundamental rights, and those writs are of course have come from the British parliamentary tradition, but nonetheless they are quite important. And in recent years we have seen that these writs are being used by the Supreme Court to basically to give directions to executive most of the time, but sometimes to legislature also, for getting certain things, certain work done, and therefore this entire debate on judicial activism is often related to this issuance of writs under article 32. Now, some scholars argue that the judicial review comes from article 13 of the Constitution, that is the first important article of the fundamental rights section, which say that no law which encroaches upon this thing will be tolerated, or any law which encroaches upon fundamental rights can be declared null and void by the Supreme Court. And therefore, some jurists, some scholars argue that the judicial review in India essentially comes, the power of judicial review of the Supreme Court essentially comes from article 13, whereas judicial activism scholars argue that that comes from article 32 through these extraordinary writs in nature of habeas corpus, mandamus, certiorari, prohibition and quo warranto. So, this is how this writ jurisdiction is concerned. The fourth important jurisdiction, which is a later addition, and it is called epistolary jurisdiction, particularly after this innovation of public interest litigation, and this public interest litigation has led to opening of a new channel for Supreme Court to intervene in number of social and other issues. Particularly in recent years, we have seen that the way these PILs have proliferated, the way the Supreme Court basically modified and relaxed this provision of locus standi rule earlier, that only those who were affected parties could move to the court. Now, when it was basically modified and relaxed, and now anyone in public interest could move to the Supreme Court for redressal of grievances, that led to new era, that is remembered as era of public interest litigation, and that has added a new jurisdiction to the Supreme Court. We will basically look at this PIL era and this new innovation in course of our discussion of judicial review and judicial activism toward the end of our lecture. So, this is how this jurisdiction part is concerned. Now, that brings us to another dimension, that is independence of the judiciary in India. And here in fact, we have already discussed appointment and removal, but they are not the only things through which this independence has been secured. There are few more things which can be added here so far as independence of judiciary is concerned. And some of the other things apart from appointment and removal process are the salary structure and how the action of the judiciary and the judges have been made immune from criticism, that the judges' conduct cannot be discussed on the floor of the parliament, it cannot be discussed in public, it cannot be discussed in media, and therefore that can attract contempt of court. And therefore, this is one of the important protection so far as the independence of judiciary is concerned. The idea is that the judges can freely act, the judges can freely express their views without having the fear that it will be scrutinized in the public or it will be unnecessarily subjected to criticism, personal or otherwise. So, therefore, this action, immunity given to the action is a very important precautionary measure taken in the constitution so far as the independence of judiciary is concerned. Similarly, salary, because the salary of the judges comes from the consolidated fund of India, and that is also one important feature of this independence of judiciary, particularly in the constitution. And last but not the least, that is the own establishment. The judiciary, particularly Supreme Court, has full control on its own establishment, appointment, its administration and transfer and so on and so forth. So, therefore, what we find that through appointment, through removal, through salary coming from consolidated fund of India, immunity of actions and finally control on its own establishment, this independence of judiciary has been secured so far as India is concerned. Now, that brings us to the next important issue, that is judicial review. As I was mentioning earlier, that judicial review in India is now integral to this entire constitutional discourse. No one can deny that India today stands as one of the cases of a democratic polity, where judiciary, particularly the Supreme Court, is using this power of judicial review in such a powerful and effective way that many scholars argue that even the Supreme Court of United States of America, which perhaps devised this entire mechanism of judicial review in Marwari versus Madison case and the Chief Justice Marshall's doctrine, they get overshadowed, because in fact one of the jurists, Upendra Bakshi, has argued that Indian Supreme Court is the only Supreme Court in the world which reviews not only the acts of the legislature, but also reviews amendment process, amending power of the parliament, which no other Supreme Court does except India. So, therefore, Indian judicial review has basically gone much ahead of what it was perhaps visualized by the founding fathers. As I was mentioning earlier, when procedure established by law replaced this doctrine of due process in the constitution, particularly in article 21, which gives freedom of life and liberty. This was intentionally done because it was basically believed at that time that due process might lead to many litigation, because it gives unfettered power to the judges to interpret laws as per natural rights, natural law and natural justice. And therefore, in order to constrain it, in order to tie the hands of judges and judiciary, due process doctrine was replaced by another doctrine that was called procedure established by law, that only the procedural aspect of the legislation or the act of parliament would be reviewed, not the substantive issue. But Indian Supreme Court was not contented with that, and in course of time, in spite of the fact that the constitution still retains that procedure established by law doctrine, it has gone beyond it, and in number of cases there are many case laws available. For example, starting with Gopalan case, coming to Maneka Gandhi case, and subsequently two landmark judgments in Golaknath and Keshwanand, the Supreme Court, the way it has basically enlarged this power of judicial review, that no other judiciary in the world, no other Supreme Court in the world today can basically match with Indian Supreme Court, in spite of the fact that Indian constitution still contains the provision of procedure established by law, not the due process of law. Now, one thing is important, that this entire concept of judicial review started in India with the controversies and debate on the right to property, till it was removed as a fundamental right in 1978 under 44th Amendment. But subsequently we have seen that not only property, but liberty and equality, these three important issues have been at the basis of this entire debate and controversy so far as judicial review is concerned. Now, we will see that how this property, liberty and equality, the three concepts, have been at the center of this entire debate and controversy between the judiciary, the Supreme Court and the Parliament. Parliament trying to amend constitution to implement directive principles of a state policy in order to enforce some of the social welfare measures, and Supreme Court considering it interference in the fundamental rights, particularly right to property. And similarly, on the question of liberty and preventive detention and encroachment on the domain of freedom, how Supreme Court considered fundamental right to be sacrosanct, whereas the Parliament at times believed that the security of the state, security of the society, public order, this liberty could be constrained, and therefore the Supreme Court expanded its ambit by basically taking on the legislature and executive and declaring many acts null and void. And later on we have seen on question of equality, particularly on affirmative action, on question of reservation, particularly the two important judgments, Indira Sohani case and later on this what is known as Mandal 2 judgment. In fact, the Supreme Court has given ample indications that the Supreme Court can go to any extent to basically review the acts of legislature and executive. If we look at the phases through which this judicial review in India has developed, then we can identify 3-4 important phases. For example, the first phase is from 1950 to 1966. This was politically a period of one party dominant system, when Congress was a dominant party in Parliament and it had a clear mandate and clear majority. At that time, two important cases came up. One was the Sankari Prasad case in 1951, particularly when the first amendment was done in the constitution and it was challenged, when the 9th schedule was created and some of the land legislations were put in the 9th schedule. And this Sankari Prasad case, we find that the Supreme Court took a different stand at that time, and it believed that the Parliament under Article 368 is empowered to amend the constitution, and it cannot be considered a law under Article 13, which is basically which gives the Supreme Court power to declare an act or a law null and void if it encroaches on fundamental rights. So, made a distinction between Article 13 and 368. Similarly, the Sajjan Singh case, particularly after the 7th amendment was challenged and some of the new legislations were put in the 9th schedule, again Supreme Court took more or less a similar stand, and in the opinion of many scholars, it was a period of harmonious construction, a harmonious relationship between the Supreme Court and the Parliament. The second phase starts with 67 to 72. This also coincides with the end of the one party dominant system and the dawn of a coalition era, not the way perhaps it emerged in 90s, but nonetheless a decline of one party dominant system. And it is here that the famous Golaknath case came, when the earlier judgment Supreme Court reversed and believed that 368 is also law under Article 13, and therefore Parliament cannot amend the constitution. If constitution is to be amended, another constituent assembly needs to be convened, and therefore it put a complete stay on the amending process, amending power of the Parliament. So this was the second phase, a confrontation, the phase of confrontation between the Supreme Court and the Parliament. Then comes the third phase, that is 73 to 79, which basically is also period when that famous doctrine of the basic structure was propounded by Supreme Court in the Keshwanand Bharti case. It related to Kerala Land Reforms Act of 1963 as it was amended in 69 and 71, and it was challenged. But along with this, 24th, 25th and 29th amendments were also challenged, and all of them were heard under this Keshwanand Bharti case, where the Supreme Court propounded this basic structure doctrine, which to great extent one can say that the beginning of the new era so far as judicial review is concerned, where from procedure established by law one can say that Supreme Court moved in direction of the due process of law without having the uses of the term in the constitution. In fact, 1800 pages were written in the Keshwanand Bharti case, but not even 18 words were used to define what is meant by basic structure. So Supreme Court didn't define basic structure and kept it to itself. This decision that from time to time it will basically review the acts of legislature and executive under this basic structure doctrine. In recent years we have seen from time to time in other cases it has basically clarified that what is the basic structure in its opinion, one by one. For example, in Bombay case it believed that secularism is the basic structure. In Jharkhand Mukti Morcha case it believed that parliamentary democracy is the basic structure. So from time to time in number of cases through case laws we can see that how Supreme Court has started expanding or rather explaining this basic structure, but not in toto but in bits and pieces. So that is the 73-79. Then comes 1980 till date. We can say this is the phase where we have a Minerva Mill case of 1980, when the nationalization of mill took place, and then subsequently many cases related to equality, affirmative action, social justice came up, and this is how the Supreme Court expanded this view. But in between we have seen the era of public interest litigation, judicial activism, workers' rights, particularly during Asiad Games, when this workers People's Union for Democratic Rights, Bandhua Mazdoor Union, and these cases came up. Supreme Court innovated new mechanism of public interest litigation, and the two important judges, Justice Iyer and Justice Bhagwati, the way they contributed in the development of this new instrument of the judiciary, that is public interest litigation, this is worth remembering. But now in recent years we have seen that it has gone to the extent of asking Parliament to supply even the in sealed envelope the proceedings of the select committee, particularly when this seats were getting reserved for the other backward classes in educational institutions. And lot of scholars have argued that this is clear-cut violation of the spirit of the separation of power in the Indian constitution, because if judges' conduct is immune from scrutiny by the Parliament, Parliament proceedings are also immune from judicial scrutiny. But in recent years we have seen number of cases that judiciary has not only tried to review the acts of Parliament, but has also interfered in the working of the exclusive domain of Parliament and the executive. So this is how we can see that how Indian Supreme Court has moved far beyond its jurisdiction as it was laid down in the constitution.
Dear friends, on that note, I would like to thank sir for this very enriching discussion, and thank you dear friends for watching our show. Stay tuned and keep watching. Thank you.